Breaking news out of Illinois. A major case that's been going on and sponsored by the Second Amendment Foundation dealing with whether or not Illinois' firearms owner identification card laws that says you can't have a gun if you don't have one of these cards, whether or not this law is constitutional. A major step has just occurred in the court system in Illinois. I need to bring you up to speed on it in 1 second. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Box of Nine, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. If you don't have a copy yet, check it out. If you've read it already, please feel free to leave a review on Amazon. I'd appreciate the support. It helps a lot, get the word out about the Second Amendment. All right, folks. This is a crazy case, and I'm not going to get you bored with sort of the details of this, but the bottom line is, in 2017, a woman named Vivian Claudine Brown in the state of Illinois was arrested by the police because she was found to possess a .22 caliber rifle in her home in rural Illinois, which she said she, needed for self-defense. She was arrested because she had this rifle and hadn't fired, no evidence of her firing or anything like that, but she did not possess a firearms owner identification card, or a FOID card. This card, for those of you outside of Illinois, and those of you in Illinois likely know all about this, you have to have one of these cards in your possession to be able to even possess a firearm in the state of Illinois. Well, Miss Vivian Claudine Brown did not have one, but she had the rifle. So she was charged with the crime for the unlawful possession of a firearm without one of these firearm owner identification cards. And the first judge actually threw the case out on the grounds that this was unconstitutional because it was undenied, at least my understanding, according to all the record, is that there's no dispute that Miss Brown lawfully could have gotten a firearms owner identification card. She qualified 100%, no problem with her background. She just didn't go through the administrative process of doing so. And one of the decisions by the trial court that threw this out said that, by the way, the fees and forms required to receive a FOID card imposed upon Miss Brown were unconstitutional. It was an unconstitutional burden on Miss Brown's Second Amendment right to keep a firearm in her home. Remember, this is in the year of our Lord 2017. The Heller decision that says you have a right to a loaded firearm, handgun in that case, in your home, was in 2008, almost a decade before Miss Brown being charged. So Miss Brown basically went through the process. The state appealed from her dismissal, and I'm not going to bore you with this, but this case is literally because of procedural posturing by the courts in Illinois, in my view, to dodge answering the ultimate question of whether or not this law is constitutional. It's clearly not. But the Illinois court system has literally bounced Miss Brown up and down since 2017. So just yesterday, the appellate court of Illinois in the 5th district sent this case back down to the trial court again for further consideration of whether or not this law is constitutional, because all the Illinois mishigosh, procedural posturing issues going on, continue to this day. In fact, just back in 2022, the Illinois Supreme Court had a chance to resolve once and for all whether or not the FOID Act was constitutional, and in a 4-3 decision, the 4 justices in the majority said, we need more procedural posturing. There's some issues here involving Illinois procedural law. We can't rule on it, over a vigorous dissent from 3 Republican justices, I believe, on the Illinois Supreme Court, saying, this is absurd. You're dragging this woman through the mud. It's taken too long. This case started in 2017. It's already in 2022. What are we doing here? So now we sit here, and it's going back to the trial court. We're in 2023. Now, the good news is, despite the fact this justice delayed is justice denied, in my view, the good news is, I think, articulated by the founder and head of the Second Amendment Foundation, Alan Gottlieb. This is what Alan Gottlieb said about this decision, that finally we're going to get some resolution on whether or not the firearms owner identification law of Illinois is constitutional. He writes, quote, "We are delighted that the courts will finally have an opportunity to hear arguments in the actual case which challenge the constitutionality of the FOID card," Alan Gottlieb said. Quote, hopefully this time around we won't see the case bogged down by more procedural issues which have allowed the court to avoid addressing the main issue at hand, which is whether the firearms owner identification card requirement actually passes constitutional muster. Gottlieb continues that this case has been bouncing around for 6 years and it is high time to move forward. I could not agree more with Alan Gottlieb of the Second Amendment Foundation. Enough is enough. It seems to me that Illinois judges, at least some of them, are trying to dodge the ultimate question about whether or not this firearm owner's identification law is constitutional, because it clearly is not. Because you have a right to have a gun loaded, unlocked in your home under Heller. Nevertheless, we need to get an actual ruling by the Illinois Supreme Court on this question, or by some court, and presumably that will be the Illinois Supreme Court at some point down the road. Well, I'm not happy to say this is going to keep going on for a while, but the good news is it appears to finally be on a procedural posture path where we're going to get to the merits of this case and hopefully a final ruling, because it's simply unfair to Miss Vivian Claudine Brown, and also unfair to all those gun owners in Illinois that have to deal with this nonsense out there in that state, a state that seems to be largely ruled over by the urbanites in the city of Chicago, even though much of Illinois is actually red state America that supports the Constitution and the Bill of Rights, including the right to keep and bear arms. Nevertheless, Chicago appears to be essentially capital city in the movie and book The Hunger Games, trying to lord over the rest of the hardworking Illinois residents. But again, I'm sure our friends in Illinois have a lot more to say about this and are much more informed on this question than I am, so I'll let them do the talking in the comments below. But for now, let's all wish Vivian Claudine Brown good luck and Godspeed, and hope she knocks that law out once and for all, because you should not have to get a license for exercising a fundamental right, including the right to keep and bear arms. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.